The International Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please, the matter.
Good morning, Mr. President, Your Honors. Situation in the Republic of Côte d'Ivoire. In the case of the prosecutor versus Laurent Gbagbo and Charles Blé Goudé. Case reference ICC 0211-0115. And for the record, we are in open session.
Thank you very much, officer. Now, we will take appearances, beginning with counsel for the prosecution.
Good morning, Your Honours. Appearing today for the prosecution, we have Mr. Reinhold Galmetzer, Appeals Counsel, Ms. Priya Narayan, Appeals Counsel, Mr. Eric McDonald, Senior Trial Attorney, our case manager, Ms. Neera Mandavia, and I'm Helen Brady. I'm the Senior Appeals Counsel. Thank you.
Thank you. And next appearance is from counsel for Mr. Gbagbo.
Bonjour Monsieur le Président, bonjour Mesdames, bonjour Messieurs. L'équipe de défense est composée de Jennifer Naouri, qui est à côté de Laurent Gbagbo, derrière moi du professeur Jacobs, de Fiona Gantré, assistante juridique, Galadriel Marchais, case manager, et Angèle Jean-Georges, case manager, et quant à moi, je suis Emmanuel Tite, avocat principal de Laurent Gbagbo.
Merci. And next up, counsel for Mr. Blé Goudé.
Good morning, Honours. Mr. Blé Goudé is today represented by co-counsel Mr. Claver Nindri, my left side. In the second row, Mr. President, legal assistant Mr. Siri Zuku, the bar Brussels. Madame Antonia Dijk, legal assistant Sarah Pedroso. And on the second row, you find one of our new assistants, Ms. Deswina, and I have to pronounce it very correctly, I was told, Elefirio. I hope I pronounced it correctly. Thank you, Mr.
Can
President.
you spell it, please, for the record, so that
Yes.
the court record can get it correct?
Yes. We can also send the names later to you, to save time.
Fair enough, fair enough.
I'm lead counsel for Mr. Blé Goudé, Alexander Knoops. Thank you.
Thank you. And the record will reflect that both Mr. Gbagbo and Mr. Blé Goudé are in the courtroom. Next, we take appearances from the Office of Public Counsel for Victims.
Good morning, Mr. President, Your Honors. Victims participating in this proceeding are represented by counsel from the Office of Public Counsel for Victims. In attendance this morning, next to me, Ms. Peña Ana, case manager, and I am Paulina Massidda, principal counsel.
Thank you very much. And lastly, we take appearances from counsel for the government of Côte d'Ivoire.
Bonjour Monsieur le Président, Mesdames, Messieurs les juges. Le gouvernement de Côte d'Ivoire est représenté à votre audience par Maître Mignard, Maître Blard, avocat au barreau de Paris, et moi-même, avocat au barreau de Paris, et Maître Mamadou Koné et Maître Abdoulaye Maïté, avocat au barreau d'Abidjan. Je vous remercie, Monsieur le Président.
Thank you very much. We also take appearances from the office of the registrar.
Je vous remercie, Monsieur le Président, Mesdames et Messieurs les juges. À mes côtés, sur le banc du greffe, il y a Jamila Zoubir, juriste coordinatrice, et Romina Morello, conseillère en coopération et en relations extérieures. suis Marc Dubuisson, le directeur des services judiciaires et je représente le greffier Peter Lewis. Je vous remercie.
Thank you very much. We've taken appearances from everyone. Thank you. The appeals chamber is convened to hear oral submissions in the application of Mr. Gbagbo, dated the 7th of October 2019, requesting the appeals chamber to reconsider an earlier decision, which hereafter I will refer to as request for reconsideration. I will now summarize the background to the proceedings of today. By a majority judgment announced on the 15th of January 2019, the trial chamber acquitted Mr. Gbagbo and Mr. Blé Goudé of all charges against them in the present case. Judge Herrera Cabuchia dissented. The next day, on the 16th of January 2019, the prosecutor made an application to the trial chamber requesting that Mr. Gbagbo and Mr. Blé Goudé should not enjoy the benefit of absolute freedom that usually accompanies an acquittal. Instead, they should only be released subject to conditions to a state willing to accept them on its territory with such conditions. But in the event that no such state may be found, the prosecutor requested that Mr. Gbagbo and Mr. Blé Goudé should be kept in detention pending the outcome of the appeal that the prosecutor intended to file against the acquittal. The trial chamber, by majority, rejected that application. Again, Judge Herrera Cabuchia dissented. On the 23rd of January 2019, the prosecutor appealed against the trial chamber's decision rejecting her request for conditional release of Mr. Gbagbo and Mr. Blé Goudé. On the 1st of February 2019, the appeals chamber had oral submissions from the parties and participants in that appeal. On the same day, the appeals chamber issued its decision on the prosecutor's appeal on that matter. In the decision, the trial chamber did the following, amongst other things. A, the appeals chamber amended the trial chamber's decision and imposed conditions on Mr. Gbagbo and Mr. Blé Goudé upon their release to a state willing to accept them on its territory and willing and able to enforce such conditions. B, the appeals chamber directed the registrar to identify and enter into arrangements with a state willing to accept Mr. Gbagbo and Mr. Blé Goudé, or both of them, on their territory and enforce the conditions. And C, the appeals chamber indicated that it may vary the conditions of release in the future. On the motion of the appeals chamber itself or on the motion of a party or participant. On the 7th of October 2019, Mr. Gbagbo filed his request for reconsideration of the appeals chamber's decision of the 1st of February 2019. Responses to Mr. Gbagbo's request for reconsideration were received on the 16th and 17th of October 2019. On the 20th of December 2019, the appeals chamber scheduled a hearing in this matter to be held on the 6th and potentially also the 7th of February 2020. With leave of the appeals chamber on the 22nd of January 2020, the government of Côte d'Ivoire filed observations in relation to Mr. Gbagbo's request for reconsideration. On the 30th of January 2020, the Appeals Chamber issued a decision on the conduct of the hearing, including questions to guide the submissions of the parties and participants, as well as the order in which they are invited to address the Appeals Chamber. That is a summary of the background to the proceedings of today. Turning now to the conduct of these proceedings, it is recalled that in the decision on the conduct of hearing, the Appeals Chamber indicated both the order and the time allocated to the parties and participants to address the Appeals Chamber. The proceedings will thus be conducted in accordance with that schedule. Before we begin with hearing from Council, I would like to direct the parties and participants on a few modalities with respect to the hearing. In addressing the issues, the participants should be guided by the questions set out in the decision on the conduct of the hearing. They are free to speak to these questions in the manner that is most convenient to them. May I also remind Council that they are expected to complete their submissions within the indicated time frame. The court officer will be monitoring the time and will indicate to the party or participant 5 minutes before the end of the time that the time is about to end. The time allocated is based on 3 court sessions with time for questions from the bench, which may come at any time. Without further ado, I now recite the questions that the parties have been given to keep in mind. 1. In what circumstances may the Appeals Chamber reconsider its judgment taken pursuant to Rule 158 of the Rules of Procedure and Evidence? B. If the Appeals Chamber may reconsider its judgments taken pursuant to Rule 158, what is the applicable standard? Beyond the question of reconsideration, are there any other reasons for the Appeals Chamber to review and revoke the conditions of release set out in its decision of the 1st of February 2019? D. Does the relief sought by the prosecutor in her appeal brief in the main appeal against the acquittal of Mr. Gbagbo and Mr. Blé Goudé, namely the declaration of a mistrial, have any bearing on the necessity of the continued imposition of the conditions of release set out in the judgment? Those are, in brief, the questions the parties are to turn their minds to in addressing us. Now, I would invite submissions from Council. Council for Mr. Gbagbo will go first, and you have 30 minutes.
Merci, Monsieur le Président. Monsieur le Président, Mesdames, Messieurs, c'est le professeur Jacobs qui va s'adresser à la Chambre sur ces questions.
Monsieur le Président, Mesdames, Messieurs les juges, pour répondre à votre première question concernant les circonstances dans lesquelles une chambre d'appel peut reconsidérer un jugement rendu sur la base de la règle 158 du règlement de procédure et de preuve, la position de la défense est la suivante. D'abord, sur la question de la reconsidération en tant que telle. Entre reconsidération et réexamen, nous avons estimé que la reconsidération s'imposait. Pourquoi ? Parce que la reconsidération touche à la raison d'être sur laquelle est fondée la décision dont on demande qu'elle soit à nouveau examinée. Ici, la décision du 1er février 2019. Tandis que le réexamen touche aux modalités, non à sa raison d'être. Or, c'est bien la raison d'être des restrictions imposées à la liberté de Laurent Gbagbo que nous avons discuté dans notre requête du 7 octobre 2019. En effet,
Council, do you have authority for that definition of distinction between reconsideration and review? Is there a legal authority that you can refer to us that should guide that understanding?
merci Monsieur le Président. Il nous semble que c'est la logique même de ces deux opérations qui commande cette distinction. Dans la mesure où le réexamen permet de redemander à une chambre de revoir certaines conditions selon les changements de circonstances, etc., et nous y viendrons dans un moment, alors que la reconsidération permet de demander à une chambre de revoir le fondement même d'une décision, notamment, et je vais y venir, pour éviter une injustice, par exemple, ou sur la base d'un raisonnement erroné, ou d'un manque de fondement factuel, etc. La défense estime donc que sur le principe, il ne peut être imposé de restriction à la liberté d'une personne acquittée, qui doit pouvoir exercer l'intégralité de ses droits, y compris ses droits civils et politiques. Ce principe est reconnu par toutes les juridictions internationales des droits de l'homme. Par exemple, la CEDH, dans son arrêt L'Habitat de 2000, et je cite le paragraphe 171 de cet arrêt, a estimé que la détention justifiée au sens de l'article 5, paragraphe 1c, prend fin le jour où il est statué sur le bien fondé de l'accusation. Et que par conséquent, la détention d'un individu après son acquittement ne saurait plus être couverte par ladite disposition. Fin de citation. À cet égard, la défense note que l'arrêt Hassanidze de la CEDH de 2004 va dans le même sens, contrairement à ce qu'essaie de lui faire dire la représentante légale des victimes dans sa réponse datée du 16 octobre 2019 à la requête de la défense. En effet, la représentante légale des victimes affirme, sur la base de cet arrêt, qu'il suffirait qu'une décision de justice existe pour qu'une restriction de liberté imposée à une personne acquittée soit légale. Et je vous renvoie au paragraphe 37 de l'écriture 1278 de la représentante légale des victimes.
The authority you cited from the European Court of Human Rights was saying that detention is no longer valid upon acquittal. But Mr. Gbagbo is not in detention. Is there a difference?
Monsieur le Président, nous estimons que
okay, I was told that I had not activated my microphone. Thank you, colleague. My question was this, that the detention, the authority you cited from the European Court of Human Rights was focused on detention of an acquitted person. But my question is that Mr. Gbagbo is not in detention. So does that authority apply? Does it guide our discussion now?
Merci, Monsieur le Président. Nous estimons que la jurisprudence de la CEDH peut être appliquée à toute mesure restrictive de liberté imposée à une personne acquittée. Et que le principe est clair, une personne acquittée est mise en liberté immédiate en l'absence de toute raison, par exemple liée à d'autres affaires en cours, ou c'est ce que la jurisprudence dit. Mais en lien, une fois qu'une personne est acquittée, il n'existe aucune base juridique d'imposer des mesures restrictives à sa liberté, qui vont de la détention à des conditions de mise en liberté. C'est notre compréhension de la jurisprudence, Monsieur le Président.
Does that scenario take its bearing from the essential circumstance that in a national jurisdiction, when an accused person is acquitted in a national jurisdiction and there is an appeal against that acquittal, if that appeal succeeds, it's just a matter of the police attending and rearresting that person for purposes of any further trial. So in a national jurisdiction, that would not pose a serious problem as such. But on the ICC, there is that disability that the court does not have the facility of going and having somebody rearrested so easily. It is a need to continue a trial. Does that scenario make a difference? If not, why not?
Merci, Monsieur le Président. Deux choses. La première est nous considérons que le respect des droits fondamentaux est un principe absolu et qui ne doit pas s'accommoder de questions pragmatiques. La justice pénale internationale se pose en modèle d'exemplarité en cette matière. Et donc la question pragmatique de la différence avec des juridictions nationales par rapport à ce que vous disiez, nous estimons que ce n'est pas pertinent ou ça ne permet pas de déplacer l'application stricte du respect des droits fondamentaux. Premier point. Et le deuxième point, par rapport à ce que vous disiez, je vais y venir tout à l'heure, mais il y a une différence ici, dans la présente procédure, c'est que le procureur demande un mistrial. C'est-à-dire que même si son appel est reçu...
But that's a different consideration. If you want to base an argument on that, there is a separate argument segment. But you just said that the distinction doesn't matter, you say. Simply you said it doesn't matter. And the premise of that argument is because you say the respect for human rights is an absolute principle. Is it an absolute principle? Does the European Convention on Human Rights and does the International Covenant on Civil and Political Rights say that human rights are fundamental absolutely so. There is never a scenario where some exceptions may be made. Is that what you're saying?
Alors qu'il existe des possibilités dans les traités des droits de l'homme d'opérer des dérogations, par exemple, de certains droits. On ne va pas rentrer dans cette discussion aujourd'hui, mais c'est une possibilité technique. Certains droits sont non dérogeables dans les conventions internationales. Mais pour
But
répondre...
that's exactly where we are. We want to see the limits to which some of these liberties could be modulated, offset by other considerations others may think are also valid considerations. And you're saying we're not going to go there. But that is exactly where we are.
Monsieur le Président, pour répondre de manière simple à votre question, la réponse est non. Il n'y a pas de considération pragmatique qui justifie de déroger à un droit de l'homme qui est reconnu. Le droit à la liberté est reconnu comme un droit non dérogeable. Le fait qu'il puisse y avoir des difficultés pragmatiques au niveau de la justice internationale ne justifie pas de déroger à un droit fondamental d'un individu. Et si vous me permettez, je voudrais rappeler que la Cour suprême du Kosovo...
Now, first, I do not know whether there has been misinterpretation. I did not say pragmatic considerations. I said other considerations.
Merci, Monsieur le Président. J'ai moi-même utilisé le terme pragmatique puisque vous souleviez, pour moi, ce que je considérais être une question pragmatique de la réarrestation d'une personne par opposition à un problème de principe. Donc, comme je disais, la Cour suprême du Kosovo a elle-même, par rapport au tribunal spécial pour le Kosovo, qui est une juridiction hybride internationale, le 26 avril dernier, a refusé d'adopter une disposition identique à l'article 81.3 CI du statut de Rome, sur la base du fait que cette disposition était contraire, 1, à la Constitution du Kosovo, et 2, à la jurisprudence internationale des droits de l'homme. C'est donc un tribunal international a considéré que même dans les circonstances que vous décriviez, il n'était pas possible d'imposer des restrictions à la liberté d'une personne acquittée.
Professor Jacobs, is there any difference in principle between an acquitted person who is gone through a judicial or legal proceedings and a person who is accused of an offence but is nevertheless to be regarded as innocent under the presumption of innocence?
Alors, comme vous le savez, nous avons de manière constante et systématique demandé la liberté du président Gbagbo, de Laurent Gbagbo, pendant le procès, justement pour respecter la présomption d'innocence et son droit à la liberté, comme un principe même pendant les poursuites. Donc ça, c'est le point de départ, le droit à la liberté qui existe aussi pendant le procès. Nous sommes une étape plus loin. L'acquittement par le tribunal de poursuite.
Dealing with it as a matter of principle, Professor, the reality is that in many cases where somebody is awaiting trial and is presumed innocent until that trial has been completed according to due process, there are restrictions often placed upon a person's liberty. For instance, they may be required to surrender their passport to the police or to regularly attend at a police station in order that they should not flee the jurisdiction. That's commonplace as conditions of bail pending a trial, and yet that person is to be regarded as innocent under the presumption of innocence.
Merci, Monsieur le juge. Effectivement, ces circonstances existent. sachant, il est important de le rappeler, que ces mesures ne peuvent être imposées que s'il existe des risques identifiés, concrets, matériels, démontrés, pour déplacer ce qui est la règle, c'est-à-dire la liberté, même pendant le procès. Et encore une fois, l'acquittement change la situation, change radicalement la situation pour nous. Et c'est bien ce qui ressort de la jurisprudence, notamment des droits de l'homme, qui dit qu'une fois que la personne est acquittée, il n'existe plus de base juridique dans la Convention pour imposer des mesures restrictives de liberté. Ce qui n'est pas le cas pendant le procès.
Is public order a ground for modulation of human rights?
Alors oui, la Convention permet des dérogations sur la base de la protection de l'ordre public, mais encore une fois, ces dérogations doivent être démontrées. Les risques doivent être démontrés, réels, basés sur des faits objectifs et identifiables. Ça ne peut être une allégation vague d'un risque potentiel à un ordre public. Il faut qu'il y ait des éléments concrets, matériels, qui justifient l'imposition de restrictions. Ça ne peut pas être une dérogation générale.
I doubt that many people will disagree with that proposition that it cannot be based on vague, modulation of human rights, subtraction of human rights cannot be based on vague suppositions. I think many would agree with you. So then it boils down ultimately to a matter of demonstration of the reason for the exception, isn't it? And if it boils down to that, what does it do to your original premise that human rights is an absolute principle, cannot be derogated from?
Monsieur le Président, le fait qu'il puisse exister des dérogations à certains droits ne s'applique pas à tous les droits. Et notre position est claire. Le droit à la liberté d'une personne acquittée est non dérogeable, quelles que soient les circonstances.
You may proceed.
Merci, Monsieur le Président. Donc, brièvement, je vais examiner ce qu'est la reconsidération à la Cour pénale internationale. Il est de jurisprudence constante devant cette Cour que la reconsidération est possible si une erreur manifeste de raisonnement a été démontrée ou si elle est nécessaire pour prévenir une injustice. Et je cite par exemple la décision rendue par la présidence de la Cour dans l'affaire Katanga, décision 38-33 du 26 juin 2019, paragraphe 25. Il a été aussi posé par cette Cour qu'une chambre peut reconsidérer ses propres décisions dans les circonstances où elles sont manifestement mal fondées et si leurs conséquences sont manifestement insatisfaisantes. Et je renvoie par exemple à l'affaire Lubanga, décision 2705 du 30 mars 2011, au paragraphe 18. Cette jurisprudence s'inspire assez directement de la jurisprudence des tribunaux ad hoc et d'autres juridictions internationales. Par exemple, le règlement de preuve du tribunal spécial pour le Liban prévoit en son article 140 la possibilité d'une reconsidération, et je cite, « si cela s'avère nécessaire afin d'éviter une injustice ». l'on voit bien ici le fil conducteur de cette jurisprudence, permettre la reconsidération afin de prévenir une injustice. Ici, une atteinte prolongée aux droits d'une personne acquittée et des limitations drastiques à sa liberté d'aller et venir, sa liberté d'expression et sa liberté de citoyen. Il est important aussi de noter que l'atteinte au droit n'est pas figée une fois pour toutes. Elle est de plus en plus profonde au fur et à mesure que le temps passe, puisque les atteintes provisoires au droit de l'acquitté se transforment en amputation durable. L'acquitté est dépossédé du fait du temps qui passe, durablement de ses droits les plus essentiels, de citoyen et d'homme. Autre élément à prendre en considération, le contexte procédural. En effet, l'appel formé par l'accusation, qui étend de façon importante la période pendant laquelle Laurent Gbagbo est privé de ses droits, commandait la reconsidération. C'est-à-dire que l'on examine la situation à la lumière de ce nouvel élément. L'acte d'appel de l'accusation date du 16 septembre 2019. Notre demande...
Counsel, one second, please. The reason I needed to intervene, I want to separate two things. You move from one thing to the other now. So first, let's consider the first matter. You're now talking about the extended period in which you say necessitates reconsideration. So that's a separate proposition. But dealing with your original premise as to clear error, that's what I want to get at now. Say the jurisprudence authorizes reconsideration where the original decision was based on clear error. That's what I wanted to address us now. And the argument to make in that regard as to clear error. Are these new arguments? Were they not made in the original debate on whether or not to grant the conditional release? The argument that to grant conditional release would be limitation of freedom. And that should not be. That was argued before, wasn't it, the case? If that was argued before, and the appeals chamber nevertheless proceeded, can we say that there is a clear error that warrants reconsideration, or are you just re-arguing against the judgment of the appeals chamber afresh?
Merci, Monsieur le Président. Alors, nous avons effectivement exprimé cette position de principe lors des audiences du 1er février 2019. Néanmoins, la question de l'erreur claire de raisonnement s'attache non pas à nos arguments de l'époque, mais au raisonnement de votre Chambre dans son arrêt du 1er février 2019. Et donc, jusqu'à ce que l'on puisse prendre connaissance de cet arrêt, nous ne pouvions pas savoir la manière dont vous alliez argumenter cette question, la base juridique que vous alliez adopter. Et par exemple, dans notre requête du 7 octobre 2019, nous avons pu expliquer pourquoi, selon nous, les articles du statut de Rome ou les règles du règlement que vous aviez cités dans votre décision ne permettaient pas de justifier l'imposition de restrictions à une personne acquittée. Nous n'avions pas connaissance de ces dispositions que vous alliez utiliser lors du débat précédent de la décision. Donc le fait que notre position de principe n'ait pas varié, n'ait pas changé, ne veut pas dire que nous ne puissions pas soulever des questions précises qui émergent de votre décision elle-même en termes de raisonnement ou d'erreur de droit ou de fait. selon nous. Et ça ne devrait pas interdire la reconsidération. Puisque par définition, les parties présentent des arguments devant les chambres avant toute décision. Si ce fait-là devait interdire toute reconsidération, il ne pourrait jamais y avoir de reconsidération.
Professor Jacobs, I have to be slightly cautious. You've quoted the jurisprudence of the Special Tribunal for Lebanon, the Rules of Evidence and Procedure, and the reason I have to be slightly cautious is that I assisted in the drafting of that when I was a judge in that court many years back, and I'm trying to recall the parameters of the expression "to avoid injustice." What you're saying is that something which might not have been so readily apparent as an actionable injustice at a point in time, nevertheless might grow and mature into an active injustice as a result of what happens or what doesn't happen through the passage of time. Is that a basic but fair understanding?
Monsieur le juge, oui, c'est notre position. C'est-à-dire qu'à partir de l'injustice initiale, qui est la mesure de restriction de liberté, le passage du temps renforce et assoit de manière concrète et durable cette restriction et cette atteinte à la liberté et donc à cette injustice. C'est un argument qui permet, en sus des autres arguments, de justifier de la reconsidération. Je poursuis. Alors, je vais maintenant passer pour avancer sur la question du standard, qui est votre deuxième question. Nous y avons en partie répondu, puisque dans les circonstances dans lesquelles une reconsidération est possible, chaque circonstance comporte en elle son propre standard, d'une certaine façon. Donc s'il s'agit de prévenir une injustice, le standard applicable passe nécessairement par la démonstration de l'injustice. S'il s'agit de démontrer une erreur de raisonnement ou qu'une décision est mal fondée, la jurisprudence exige que ces erreurs soient démontrées de manière manifeste. Alors je ne reviens pas ici sur le détail de notre requête du 7 octobre, mais nous estimons que dans cette requête, nous avons effectivement démontré que, comme je viens de le dire, d'un point de vue juridique, il y avait manifestement une absence de fondement. Et je rajouterai que d'un point de vue factuel, nous avons estimé que la Chambre d'appel, dans sa décision du 1er février 2019, ne faisait que renvoyer à d'anciennes décisions de la Chambre de première instance pour alléguer d'un risque de fuite, sans elle-même faire une évaluation de ce risque, sans elle-même évoquer un quelconque fait concret, matériel qui puisse fonder un risque. Et donc nous estimions que ça ne permettait pas d'asseoir factuellement la décision. Et surtout, nous soulignons que la Chambre d'appel, votre Chambre, dans son arrêt du 1er février 2019, a décidé de faire confiance au juge de la Chambre de première instance, en renvoyant à ses décisions antérieures, de 2017, 2018, lorsqu'il s'agissait d'utiliser des décisions qui maintenaient Laurent Gbagbo en détention. Mais tout à coup, lorsqu'il s'agissait de faire confiance à cette même Chambre de première instance, qui le 15 et 16 janvier 2019 a prononcé la mise en liberté immédiate, tout à coup la Chambre d'appel décide de ne pas les suivre, alors que c'est la même Chambre à laquelle la Chambre d'appel a fait confiance pour les décisions de 2017 et 2018. Donc pour nous, les erreurs tant factuelles que juridiques que nous avons identifiées sont manifestes et aboutissent à une injustice. et l'injustice nous semble devoir être l'angle qu'il convient d'adopter ici pour discuter l'atteinte drastique aux droits fondamentaux d'une personne acquittée. J'en viens maintenant à votre question C. Même si la Chambre d'appel devait considérer que son arrêt était fondé et que sa décision était valable sur le principe, il n'en demeure pas moins que nous estimons qu'un réexamen, qu'il doit être procédé à un réexamen. Donc réexamen au sens de review. D'ailleurs, le réexamen, tel que vous l'avez vous-même prévu, au paragraphe 4 du dispositif de votre arrêt du 1er février 2019. Concernant le cadre applicable à ce réexamen, par analogie avec les procédures de réexamen de la détention au cours du procès, où la charge de la preuve repose sur l'accusation, et comme le soulignait le juge Morrison, du fait de la présomption d'innocence, il appartient ici logiquement à l'accusation qui s'oppose à la levée des conditions et éventuellement à la chambre d'appel, si elle décidait de maintenir ces conditions, de démontrer que les atteintes aux droits sont justifiées aujourd'hui, dans le contexte actuel, pour des raisons dirimantes. Alors, brièvement, 3 raisons pour lesquelles il devrait y avoir un réexamen. Premièrement, comme nous l'avons dit tout à l'heure, comme je l'ai dit tout à l'heure, l'appel formé par le procureur.
Counsel, you have 5 minutes left.
Merci. Donc, premièrement, comme nous le disions tout à l'heure, l'appel du procureur constitue pour nous un fait nouveau, puisque avec l'appel, les atteintes aux droits de Laurent Gbagbo s'accentuent du fait du temps passé. Deuxièmement, il convient que la Chambre d'appel explique concrètement et matériellement sur quelle base factuelle elle se fonderait pour décider de l'imposition de restrictions à la liberté de Laurent Gbagbo aujourd'hui. Et comme nous l'avons déjà dit, il ne suffit pas de renvoyer à des décisions antérieures, maintenant vieilles de parfois 3 ans. Pour nous, en l'absence de tout élément actuel, pertinent, présenté devant la Chambre d'appel, puisque le procureur, dans sa réponse datée du 18 octobre 2019, n'a apporté aucun élément concret ou nouveau permettant de justifier une restriction de la liberté, la seule issue logique est d'abandonner toutes les conditions restrictives de liberté. Troisièmement, un mot sur ce que signifie dans le cadre du réexamen le choix qu'a fait le procureur de demander à votre chambre de prononcer un mistrial. Et donc j'en viens à votre dernière question.
Would it be fair then to say perhaps that it's a question? The facility of review, rather than reconsideration on grounds of clear error, the facility of review might be the better way of dealing with a scenario where an original decision that may have seemed right at the time, but over time, when the passage of time may have shown to perhaps be inapposite. That's one way to deal with the matter, through the facility of review. Would that be your one way to look at this?
Absolument, Monsieur le Président. Nous estimons que, sous l'angle du réexamen, il est tout à fait possible pour votre Chambre de revenir sur les conditions que vous avez décidées le 1er février 2019 et que c'est une voie juridique tout à fait possible, ouverte à votre Chambre et justifiée ici. Donc, en ce qui concerne le mistrial, pour nous, cette demande de la part du procureur change évidemment les choses de manière importante. Parce qu'en l'état actuel des demandes des parties, de deux choses l'une, soit votre chambre n'accueille pas la demande du procureur, et alors le procès s'arrête. Et Laurent Gbagbo aura vu ses droits fondamentaux affectés pour rien. Soit votre chambre accueille la demande en mistrial du procureur, et dans ce cas-là, la procédure serait tout simplement terminée, puisque le procureur ne demande à ce stade ni le renvoi à la chambre de première instance, ni la tenue d'un nouveau procès. Et donc, dans ce cas aussi, de la même manière, Laurent Gbagbo aura vu ses droits affectés pour rien. D'ailleurs, dans sa réponse du 17 octobre 2019, le procureur avance que sa demande en mistrial ne change rien à l'imposition de conditions. Cette position est difficilement compréhensible, parce que si le procureur lui-même ne demande pas la poursuite du procès à l'issue de l'appel, qu'est-ce qui justifierait que la liberté de Laurent Gbagbo soit restreinte pendant l'appel ? Par conséquent, toute question relative, par exemple, à un risque allégué de fuite, ne se pose pas dans ces conditions, puisque de toute façon, en l'état actuel des demandes des parties, le procès va s'arrêter. Pour le dire simplement, il n'y a rien à fuir pour Laurent Gbagbo. Pour conclure, nous estimons que quel que soit l'angle adopté, celui du réexamen ou de la reconsidération, les circonstances font qu'il convient de lever entièrement les restrictions imposées à la liberté de Laurent Gbagbo afin qu'il puisse recouvrer l'intégralité de ses droits fondamentaux. Merci, Monsieur le Président.
Thank you very much, Counsel. We will now hear from Counsel from Mr. Blé Goudé. You have 30 minutes. We are in open session, just so you know.
Thank you, Mr. President. Mr. President, Your Honours, good morning. We'll address the first and second question together from a purely theoretical perspective, particularly in light of the fact that the court's statutory framework provides little to no guidance as to the circumstances for reconsideration of appellate decisions. Of course, needless to say that the framework does not exclude the inherent powers of the appeals chamber to reconsider its decisions to prevent an injustice, leaving apart now the question whether there was an injustice or not. We are answering these questions from a theoretical perspective for now, Mr. President. It's our view that principles of reconsideration of ICC trial chamber decisions could also apply to the appeals chamber. Practice before the ad hoc tribunals, where reconsideration of appeals chamber decisions is commonplace, may provide your chamber with additional guidance as to which test could be applied. Let us first see what the jurisprudence briefly dictates when it concerns the ICC itself, after which I will delve briefly into the jurisprudence of the ad hoc tribunals on reconsideration of appellate decisions. First, speaking about the ICC precedents, There is the decision of the 1st October 2019. That's our Exhibit 1 in our table of authorities. Prosecutor versus Nataganda, where the appeals chamber ruled on a request of the defense for reconsideration of one of its decisions, which related to the ordering of an extension of time and page limit. Although the appeals chamber did not, as itself admitted, take the opportunity to articulate the circumstances in which reconsideration might be ordered, it nonetheless granted the request in part. And interesting, Mr. President, the test which was applied and put forward by the defense was previously formulated by trial chamber number 4, the 23rd September 2019, according to which the trial chamber has the inherent power to reconsider previous decisions to prevent an injustice, paragraph 4. Again, I'm not going to the question yet whether this phenomenon occurs, whether in this situation there was an alleged injustice. We're just addressing the topic from a theoretical perspective for now. You see, therefore, Mr. President, the appeals chamber exercised in that case its inherent discretion to vary its previous decisions on an exceptional basis and took into account whether the defense had shown that reconsideration would prevent an injustice, paragraph 6 and 8 of its decision. Appeals chamber rejected the request in part, as mentioned, where it considered that the Nataganda defense merely attempted to re-argue points which were already made. What does this recent ICC appeals chamber decision in the case of Mr. Nataganda tell us, Mr. President, Your Honors? First, it's within the inherent discretion of the appeals chamber to reconsider its own decisions in accordance with Rule 158. That's our first submission. Second, it may do so to prevent injustice. 3, parties may not use reconsideration as a way to re-litigate points already made. And 4th, reconsideration might be ordered on an exceptional basis. So this is my first point, the standard derived from ICC case law. Now, let's briefly look into the appeals chamber decision and why it could apply the principles applied by trial chamber decisions to reconsider its own decisions, as it did in the Nataganda case. For instance, as a precedent in the Ruto and Sang case, that's authority number 3 on our list of authorities, the chamber held that reconsideration was not an alien concept at the court and had been occasionally granted, such as in the Kenyatta case, that's authority number 2 of our list of authorities. The trial chamber endorsed as justification for reconsideration where, I quote, it was necessary to better serve the cause of justice if the question of law is still with the chamber and there is merit to the urge for the adjustment. It seems to me, Mr. President, that this is more an extensive interpretation of the criterion to prevent an injustice. But as held by you, Mr. President, in that same case, the trial chamber, I quote from your own opinion, the opinion at the Ruto Sang decision, paragraph 87, quote, should be neither shy nor afraid to take another look at the question of law that the chamber had earlier passed upon, unquote. And therefore, it could adjust and refine a previous decision. Mr. President, you had further observed in that same opinion that, I quote, "It's not beyond the realms of possibility that the chamber did not get it fully right on the first occasion," unquote. And that suppositions of judicial infallibility are never borne out by the corrective facilities of reconsiderations, reviews, and appeals. Paragraph 136 of your opinion. Therefore, we submit, Mr. President, Your Honors, that these same principles could apply to appeals chamber decisions, and that it is precisely this reasoning which is implicit in the appeals chamber decision in Nataganda when it partially granted the defense request for reconsideration. Finally, Mr. President, touching upon the questions A and B, if the chamber would delve into the standard applied by the ad hoc tribunals, you all might find further guidance. This ample case law, we have identified 6 precedents we will mention now, in specific 3, of ICTY and ICTR appeals chamber decisions which have constantly relied on its inherent power to reconsider its own decisions in, indeed, exceptional circumstances. We mentioned 3. First, prosecution versus Stanislav Galic, our authority number 4 list, 16 July 2004, where the appeals chamber articulated a disjunctive test, either a clear error of reasoning in the decision or the particular circumstances justify reconsideration to avoid injustice. Now here I would take the liberty to answer the question of the bench addressed to Professor Jacobs, if you don't mind. First question was from Honorable Judge Warson: is there a difference between an acquittal on the one hand and a person who is charged but not yet tried and is presumed innocent? Yes, we believe there is a difference. A person who is acquitted, in that scenario, the charges are non-existent. The charges are non-existent. And therefore, the approach as to conditional release should be different. In the scenario where a defendant is charged but presumed innocent, he is still subjected to charges. And therefore, conditions to safeguard the investigation or a judicial process might be justified. But in the scenario where a defendant is acquitted, in most jurisdictions and also here, the charges are no longer existent. And that's why, in this scenario, the approach of this disjunctive test should be also put in the context of the acquittal, as opposed to the person charged but not yet tried. And secondly, the question whether the expiration of time could be a reason to say that the second prong of this disjunctive test has been met, namely to avoid injustice. The European Court of Justice, in many cases, like the first one in 1991, L'Atelier versus France, for the first time ruled that when time progresses, the grounds for conditional release or even provisional custody might attenuate. And therefore, for the European Court, that's the reason to sometimes say when a defendant is arrested because the public order has been infringed, when time passes over, that public order might perceive a certain crime different. And that might be a reason to lift provisional custody. Therefore, the expiration of time or the progression of time in itself might be an argument for reconsideration. This is just an observation from the bench of, from the bar of Mr. Blé Goudé. speaking about the case law of the ICTY,
Before you proceed, counsel, before you proceed, you tried, and we were very grateful for your assistance in trying to answer questions from the bench as to further counsel. We welcome that very much. But in the process, you engaged question from the bench as to what is the distinction between a scenario where somebody who is standing trial and presumed innocent, what's the distinction between that and someone who has been acquitted and then given back full presumption of innocence, so to speak. Your answer to that, saying there is a sharp distinction, is it that clear? Is it that clear in the circumstances of this case? For two reasons. Ordinarily, after an acquittal, if the prosecution indicates or does launch an appeal against that acquittal, does it give us that neat distinction that the charge doesn't exist anymore, which is the basis of your answer, that there is a distinction, non-existence of the charges? Can we really say that so confidently when there is an appeal of the acquittal? That's one question, a general one, in a general scenario. But in the particular circumstances of this case, there's a further wrinkle, possibly. And that wrinkle being this: the case was stopped halfway at the close of the case for the prosecution, and in no case to answer submission was made. Trial chamber accepted the no case to answer submission. The prosecutor appealed that judgment, the natural effect of which would be, should the prosecutor's appeal succeed, the trial continues. Given those two scenarios, are we able to say with confidence that there's the distinction you drew really exists so clearly?
Thank you, Mr. President. In my submission, there is no distinction between an acquittal based on a no case to answer and an acquittal after the defense has presented its case. There is a clear determination of the evidence by a bench. The bench has determined that the charges are to be dismissed, are therefore legally non-existent.
But there's an appeal of that decision.
It doesn't take away that in the scenario of an acquittal, there is a determination of the charges being made, while in the scenario of a person still charged in an investigation but presumed innocent, the charges are still there. They are not yet determined by judicial authorities and not determined as non-existent or existent. In my submission, there is therefore no differentiation whether that the determination has been the result of a no case to answer or based on a full trial with the defense presentation, because ultimately the acquittal is based on the prosecution evidence, and which is the core of the case. And therefore, doctrinally, there is a distinction between conditions pertaining to a person charged but not yet tried, and conditions to a person who is already determined not guilty. Therefore, the charges, again, for the judge are dismissed and non-existent.
So effectively, you're saying that the system needs to recognize the basic distinction in a scenario where somebody has been acquitted versus where somebody is still standing trial. That's what you're saying. But is it possible to recognize that perhaps that distinction might have been accommodated? This is not a statement from me. I'm just asking you a question now. In the sense that in the particular circumstances of this case, when they were in trial, they were in detention fully, but after the judgment of the trial chamber, they have been released from detention but placed on conditional release. Isn't that recognizing the basic distinction between one stream versus the other?
Well, this is, of course, the interpretation made by the Appeals Chamber on the 1st of February 2019. But it's really the question whether, when in combination with the time which has progressed in this case, that could be an argument for reconsideration. And I was just alluding to a very interesting question of Honorable Judge Morrison, that in my submission, legally, there is a differentiation between the two concepts.
I mean, the real position is this, isn't it? The Crown, or the prosecution rather, I reverted to my own jurisdiction for a minute there. The prosecution has to have proved its case by the time it closes its case. There's no obligation on the defence to call evidence or any evidence, and it can simply rest at that point and proceed to submissions that the Crown, the prosecution, has not proved its case. That's a plain and obvious principle, and no doubt you would say that that underscores the distinction between the two positions as well. You add to that that apart, injustices can grow, and there would be nothing unusual in a court redetermining an issue after the effluxion of time if the argument was that there had been consequences that were not foreseeable or foreseen at the time that the original order was made. This is really thinking aloud, but it's commonplace, certainly in many jurisdictions, that where somebody has not been granted bail at all pending trial, that if the trial is for any reason adjourned beyond a reasonable time, the defence is empowered to go back to the court and use that as an argument for either altering the conditions of bail or having absolute bail. And that has happened on many occasions. And you would say that the principle that underlies that is in effect, without having to give absolute detail, a principle which is active in this case.
Yeah, Mr. President, I had, at the 1st of February 2019, your chamber could not foresee, of course, the length of the appeals proceedings. So the fact that we are now dealing with also the issue of time when the appeals proceedings could ultimately conclude might also be a reason, based on the case law of the European Court, for reconsideration, in combination with the distinction between the acquittal and the situation whereby a defendant is still charged. That's my argument. It reinforces the two elements together. Mr. President, in light of the time, I see I just have 7 minutes left.
Fair enough. We'll give you a few more minutes because of questions. There's one point you made. If you can help us with that, I'd appreciate it this much, very much. You did say that among the reasons for which reconsideration may be granted, or rather grounds, is that in exceptional circumstances that may also be done. That in exceptional circumstances, reconsideration may be done. Indeed. Can you help us what we mean by exceptional circumstances?
Well, exceptional circumstances is not an invention of myself, of course. It's the presentation of the case law to the chamber. It's for the chamber to determine whether exceptional circumstances exist. There's no definition. I didn't find any definition in the case law what is exceptional circumstances. It's really depending on the facts. It could, of course, include the, for instance, unforeseeable situation that a trial, even an appeal trial, takes longer than perhaps at the time the conditions were set were foreseen, that might be an exceptional circumstance. But I cannot give you a clear definition.
Fair enough.
Mr. President, to conclude the questions A and B, I mentioned 3 cases of the ICTY. I mentioned Galic. I will skip it because of the time. For this precedent, I only mention 2 other examples we mentioned in exhibit in our table of authorities, authority 5 and 6, the Prilic case and the Stanisic and Soplian case, where you also find the same test applied by the appeals chamber as compared with Galic. Now, we turn now to the question D, and I'll close with question C. Is there a reason, now the prosecution request for mistrial, is that a reason to reconsider the decision of the chamber of the 1st February 2019? Also here, Mr. President, we as defense team for Mr. Blé Goudé will address this topic purely from an international law perspective, purely from a theoretical perspective, without giving any normative conclusions. A mistrial would mean, and you will find in our appeal brief in due course, a more extensive expose of what is a mistrial under certain jurisdiction, but a mistrial could have the effect of rendering the first trial against Mr. Charles Blé Goudé null and void. Therefore, it would imply that the proceedings are no longer to be considered necessary under Article 81(3)(c) sub 1 of the statute. That is, for us, the logical and legal sound result stemming from the observation that proceedings are no longer necessary and need to be safeguarded, assuming, of course, hypothetically, that a mistrial would occur in this case. Now, the conditions on Mr. Blé Goudé's were imposed after the appeal chamber found merit in the prosecution assertion that there was a risk of Mr. Blé Goudé to flee the country after acquittal and not appearing for the court, such that the proceedings against him might continue in the event the appeal chamber would reverse the decision. Conditions imposed by on Mr. Blé Goudé were found necessary by your chamber upon request of the OTP, therefore to safeguard the integrity of the proceedings. Given that in the present case the prosecution seeks for a mistrial and no retrial, leaving apart the legal basis for it, that's for the appeal itself, of course, Article 81(3)(c) sub 1, therefore the basis upon which your chamber rendered its judgment on the 1st of February no longer applies. And this might also constitute, I say, a reason for reconsideration. At the time your honors rendered the decision of the 1st of February 2019, you were not familiar with this relief the prosecution is seeking for. Now, the chamber is confronted with a totally different relief than expected. That might be, answering your question, an exceptional circumstance, Mr. President. This might be an example of an exceptional circumstance which was not foreseen by the appeals chamber, which was actually not expected, could not have been expected, and therefore might justify the conclusion this is an exceptional circumstance for reconsideration, that the reasons to apply Article 81(3)(c) sub 1 therefore is no longer applicable. In conclusion, from a purely doctrinal perspective, we submit that the announcement of the prosecution that does not wish to retry Mr. Blé Goudé implies therefore already the lifting of conditions pertaining to his release, simply because that Article 83(1)(c) sub 1 no longer applies. Leaving apart, Mr. President, I stressed the question whether mistrial at this court, under the circumstances of the acquittal of Mr. Blé Goudé, can constitute a legal basis as a remedy in this case. That's something for the appeal, of course. But for now, the Chamber is confronted with a new circumstance which was not foreseeable on the 1st February 2019. Finally, Mr. President, question number C. The defense of Mr. Blé Goudé is in somewhat a dilemma. Let us suppose that the Chamber would anticipate this potential remedy. Let us suppose remedy the prosecution is seeking for. Let us suppose that you, Chamber, are willing to contemplate this potential remedy in the confines of this discussion today, preliminary discussion. Let us suppose that the Chamber, upon this anticipation, is considering the lifting of the conditions of the two accused, of the two acquitted, I have to say. Sorry. At this juncture, for Mr. Blé Goudé, it was still important that the court will impose measures which will safeguard his right to participate at the appeals proceedings without interference of the domestic authorities. And why are we seeking and asking for this measure? As the court knows from our exhibits, document 8, for instance, of the list of exhibits, the Court of First Instance in Abidjan convicted Mr. Blé Goudé on the 30th December 2019 in absentia for basically the same facts as he was prosecuted for before this court. He was convicted in absentia to 20 years imprisonment, 10 years entry ban in Côte d'Ivoire, 10 years limitation in participation of his civic life, and a fine of 200 million FCFA, based on a hearing which took less than 3.5 hours.
Counsel, as I said earlier, we are in public session, and you made reference to some filings you've made. Please keep that in mind.
I will not address the filings of the defense. I'll address just the
Fair enough.
exhibits.
What I'm saying is just keep in
understand.
mind that we're in public session.
Thank you, Mr. President.
But while at it, one thing you can help us clarify is whether now you are saying you're parting company with Gbagbo in the submission you're onto right now. In other words, you're saying that you're not in the same circumstance as Mr. Gbagbo. Is that what you're making us understand?
No.
Because when you say that, you still want some conditions to be imposed
No, Mr. President.
to ensure that Mr. Blé Goudé comes. Mr. Gbagbo is saying lift all conditions.
Yes.
And you're saying, what are you telling us? So we
Yes.
know who's where.
That's
Thank you.
Exactly. That's really a good question, and that's the dilemma. We are with the team of Mr. Gbagbo when we say from a legal perspective, and we have elaborated this extensively this morning. Legally, the conditions are to be lifted. But even when conditions are lifted, the court, in our view, has the responsibility that the acquitted person, i.e. Mr. Blé Goudé, is prevented from any external interference from his home country, which prevents him from participating at the appeals proceedings. And that's the reason why we submitted the exhibits, to show that he was subjected to a trial which was in contravention to international law.
Or maybe you can address us on that later, on what specific measures you are saying needs to be imposed. If you are saying, yes, all conditions should be lifted, so you're on the same page as Mr. Gbagbo, yet there are some measures you want put in place. So it requires some sort of fine argument to let us know exactly what it is. we're
Diplomatic
talking
pleading. Right. Yeah. Diplomatic pleading, I was saying, Mr.
about. Diplomatic pleading, you said, all right,
Yeah.
fair enough.
I can address that later, Mr. President. I can finish.
You can
my
return to
submission.
that later.
Yes. To finish, Mr. President, our submissions under question C, there are therefore also for the situation of Mr. Blé Goudé special circumstances which warrant the lifting of conditions, but at the same time, the court, when it would lift conditions, could in its disposition, in its ruling, stress the need that Mr. Blé Goudé is not at any moment subjected to interference from external proceedings, which interfere also with Article 20, Section 2 of the statute. You will see in our exhibits that this proceeding in absentia, where he was convicted in 1 hour 20 after the requisitoire of the prosecutor there, convicted, that this trial, this conviction, actually went into the same facts, the same materials as being part of the case file here. On top of this, there is evidence also shown at the trial in first instance. There's also prosecution witness that Mr. Blé Goudé was subjected, before he arrived here, subjected to an inhuman treatment by the authorities. All this is to say that if the court is to lift conditions because of the standard we suggested, because of the presence of exceptional circumstances, i.e. the potential mistrial and the other arguments, that we still seek the court to render a ruling that Mr. Blé Goudé is not to be interfered by the authorities. And, Mr. President, therefore, it is of paramount importance that this court will stress the need that his presence in The Hague is secured. That declaration itself, although we are not in an Article 20, Section 2 proceeding, in itself will be very important. We can announce, Mr. President, that this defense team will proceed for an Article 20, Section 2 application in due course, because the evidence before this chamber, produced also by the prosecution, and we submitted this yesterday in our table of authorities, and the court can look in the documents 8 till 12. Also, the arrest warrant against Mr. Blé Goudé, issued on this conviction in absentia, relates to the same facts as being put by the prosecution before this court. And the Ivorian government, in March 2014, transferred Mr. Blé Goudé for trial here. You cannot eat the cake from two sides, Mr. President. And therefore, in light of also this arrest warrant, which is issued against him, that's document 12 on our exhibit list, we, at the closing of our submissions, we seek therefore from the chamber a declaration that even if the conditions are to be lifted, that the national authorities are not to interfere with Mr. Blé Goudé's right to participate at this appeal. Thank you.
Do we understand your submission to be to ensure that if he needs to be in The Hague for his hearing, that needs to
Yes, Mr. President. That's the point we would like to make. Thank you.
All right, we'll leave it at that from you. Prosecution, I think it's your turn now.
Thank you, Your Honor. I understand that you wanted to take a break in about 10 minutes, so I wonder whether it would be a good time to break now, and that perhaps we start 10 minutes earlier, or do you want us to proceed?
You can proceed until we get to the time.
Okay, very well. In any event, before I do proceed, I would like to raise a housekeeping point, and could we go into closed session for a moment, please.
We'll go to closed session. We will do private session.
Very well.
Yeah.
Thank you.
Members of the audience, the blinds will be drawn for now, so we can have some housekeeping discussion.
We are back in open session, Mr. President.
let's see what we can do in 5 minutes. Proceed.
I'll give an overview of our position in 5 minutes. Can I proceed? So before I address you on each of the 4 questions that you posed, I'll sum up our position with the following 2 points. First, irrespective of whether and under what condition the procedure of reconsideration of judgments under Rule 158 is permissible, there is no need to resort to such a remedy in this case. This is because other procedures are available to review the Appeals Chamber's judgment of 1 February 2019. And second, there is no need to review and revoke the conditions of release set out in your judgment last year for any other reasons. This is because since the 1st of February 2019, nothing has changed. I will elaborate after the break that there has been no change of circumstances for either Mr. Gbagbo or Mr. Blé Goudé. Nothing has happened which would affect the Appeals Chamber's conclusion that their release on conditions is necessary, that they do not abscond and to prevent the appearance before the court. In addition, there has been no change in the prosecutor's position with respect to the remedy that we seek in our appeal. The prosecutor intends to continue proceedings against Mr. Gbagbo and Mr. Blé Goudé. This means that if her appeal succeeds, the prosecutor intends to retry Mr. Gbagbo and Mr. Blé Goudé. And my counsel will elaborate on that point later on. So perhaps now we can take the break, because I will then start elaborating in detail on each of the...
Fair enough. I think that you've been asking for that break. We might as well take it. This is the time for it now. The court will rise for the morning break, for reassemble in 30 minutes.
Thank you very much.
All rise, vous vous levez.
This is all very messy.